if you did that, there would literally be nothing in your estate. So if they did that, then what Mary would come in with is a blank sheet of paper in terms of the inventory. And there's still the issue of, are there any creditors that need to be paid? And then that's a question of what they're going to be paid with, because there's nothing in the estate. Remember, it's the estate that's at issue. And only things that are in the deceased's name go into the estate.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Okay, so we're back with the second and the final episode talking about George Foreman. And this episode, we're going to focus more on later life as well as the estate planning issues. So this will include talking a little bit more about the business and a little bit more about the family, but specifically about the estate planning issues. It's not necessary that you have watched part one, but it is helpful. But those of you I know who care less about the history of the individual and want more of the information relating to later life planning, so this will be your episode. Anyway, we hope you enjoy it. So Annie was, 75 or 76 when he passed?
Yes.
So this was not foreseen. It was. We still don't know why George Foreman or what caused George Foreman to pass away. He died in Houston, March 21st of this year. So it, at least outsiders didn't expect it. Now, there may have been something going on that the family foresaw that we don't know about.
But they were able to keep it. I mean, TMZ didn't get them.
And the fact that, the fact that we've looked online, Justin, you checked Reddit, trying to find any sources that had any credibility about what is the cause of death. And it's pretty hush-hush, meaning that, and I think part of it, I think, Justin, you said this a while ago, that it says something about the respect that people have for him is that...
Yeah, not a big rumor mill going around.
Yeah, I think there's so much respect by his fans that you just don't find speculations and comments much online, and that's very unusual. But we did find a couple of mentions, and we don't know that they have any better insider knowledge than any of us. One suggested, and this sounds political, one suggested it was due to the COVID vaccine. That sounds a little political, but not that I think that could be impossible, by the way. But anyway, so there's that. And then a couple references to a heart condition. And when we think about what led to his conversion to Christianity when he was, 28 years old in that locker room after that fight, which he lost so badly, when he really thought, he literally thought he was dying. He couldn't breathe. So, maybe there was something going on with his heart. He definitely gained weight, and he wasn't keeping himself in shape. So I find that theory believable. But before we talk about the estate, let's kind of talk about his business, his investments and whatnot, and what he was doing for this period of time up until that death occurred. We all know about the George Foreman grill.
Yes. And it's interesting to think about some kids. There's a generation that didn't realize he was a boxer. They just know about his grill, and they used it when they were in college to make stuff.
Yeah. Who would have thought?
Yeah.
And it really, and we have to say this, I'm sure it's a good grill, and I'm sure I've had a George Foreman grill. I don't remember it, but I'm sure that my wife and I probably, when we were young, she did have a grill, and it's probably a George Foreman grill.
And they made several different kinds over the years of that grill. They upped it a little bit here and there, added some more gadgets to it. But it really, if you look at history, it's like he was one of the first celebrities to start endorsements. That wasn't something that was going on. And, he did it and made a lot of money. And now you see so many celebrities. I just saw Paris Hilton I didn't actually see her, but I saw her at Walmart. She's got a whole line of cookware. So he kind of started it all. Yeah,
that's a good point, is that the idea of endorsing a product and going on television to sell it, that's different. I mean, just so we're clear to the audience, there were endorsements around, obviously, but the idea of taking a product like this and attaching your name to it, which has happened, a lot since then.
Oh, we see it every day now.
But at the time, that was unique. George Foreman got all in on this, And I think we can all agree, not anybody could have promoted this. This is as much about George Foreman as it is what I'm sure is a wonderful grill.
Yeah.
But George Foreman had charisma, and he had a charm about him. I'm sure as a minister he was effective in many ways.
Yeah. He had that smile. He had that unexplainable glow.
He did. It was a glow. And, you have that or you don't, in my opinion. Yeah. And George, he definitely was a charismatic guy. Yep. And I think that when he threw himself behind this product, I think everyone was amazed. I think the inventor, I think that the company that originally sought him out to endorse this product, George, I think everybody was amazed at this could produce an empire. If you want to consider probably $300+ million in revenue related to this item, probably substantially more than that. The value of the business. Let's put it this way. When he sold his interest in this business, and he had an equity interest in the business. So when he sold his equity in the business in the 90s, it was for a little less than $200 million. What was the number?
Yeah, let's see here. In 1999, he sold it for $137 million.
Okay, so $137 million. Now, this was back when $137 million was a lot of money. And it's interesting that he was able to, from the time that he launched in promoting this product in mid-90s up until this point, in a brief period of time, he managed to create value. And I do say he created primarily this value
they bought the grill for him.
Yeah.
I mean, he sold it.
It was a good grill, but you're right. I mean, he was the one who persuaded people. When he was on TV and he said, "This is my grill, you should have this grill," and people thought, well yeah.
You're like, okay.
Oh my gosh, I don't have this grill. So I mean, I think so much credit has to go to him for his initiative and his drive, something he had pretty much his whole life. I think he was losing some interest in boxing. I think it didn't challenge him in the many ways that he wanted to be challenged. So interestingly enough, he ends up being a Hall of Fame boxer who I don't think was primarily driven by boxing. I think most great boxers, certainly the best in history, are people who of whom you would say their life was boxing. This was important to them. This was very, very, very important to them. I don't think that was ever true of George Foreman, and which makes all the more spectacular the fact that he kind of, I won't say meanders his way through a career. Certainly you can't do that and do what he did. He suffered a lot, but I still think it by no means was his first love and probably not his second. And I do think that what he found in the business world, and we see this from the time that he retired from boxing. So here he is, he's 47 years old when he retired. What year was it?
It was 40. He was 48 when he retired.
And what year would that been?
1997.
97. So he retires, and he's still pretty young, and he pours himself into various business projects. But the centerpiece of his wealth, continued to be that grill. It's a great product. There are a few variations of the grill and products that he continued to endorse. And even though he sold his equity interest in this company, this manufacturer at the time, he still continued to get licensing royalties because he was considered the developer in some ways. He helped design it. I think he appears.
And commercials still, and his name is on the grill. So
yeah. But also, I know that he continued to have a licensing fee. So I'm sitting here thinking, what did he transfer with the company? So maybe what he sold was just his equity interest in the company and not his control of the product. So I don't know those details, and I don't think it's important for our purposes. But it is to say that he continued getting a lot of money after he sold this at a time when he got this huge inflow of cash, just before 2000, and invested it well, by all accounts. There's no evidence of any financial problems after that. It's also worth mentioning that he continued to have several sources of income. I know he did some things in Hollywood that
probably did a movie.
probably were not his finest hour, but
he had fun. I mean, if they call you and say, "Hey, you want to do this?" Why not? If the money's right?
And was he with ESPN when he was a ringside commentator.
He was over on HBO. HBO boxing.
Mm-hmm. So he was a ringside commentator up until after 2005. And he was well paid for that role and excellent at it for the same reasons we were just talking about this, this glib communication style that he had. He was just, he was charming and he was popular in the commentator's booth.
Yeah, well, he was also a motivational speaker.
Oh, yeah, he did that for a number of years.
He did a little bit of everything, so many careers.
He had several things going on, and not to exclude real estate investment and mainly a lot of raw land and farms. So, he was, I wouldn't say that he was somebody who was real careful with his money, meaning that he spent liberally his whole life. So he probably went out of this world with less money than he would have had he been, as cautious in his spending as some people are who make that much money. But his goal was to do good things for people. He's very generous to a lot of people in a lot of ways, and we've talked about some of those. So he goes out of this world with $300 million.
Yeah.
And as a substantial fortune. Yeah, and that's the estimated value. We don't know fully all these answers. So let me go to it, and let's talk briefly about the estate and what we know. So there's been a bit of a mystery since we found out that George Foreman had passed away in mid-March of this year. So those of us who are fans of his and many others were curious about, well, what will be in the estate, who will be the beneficiaries. He has this big family.
Yeah,
and
you have to wonder, all the kids and even some ex-wives, you never know when they come back.
Well, there could. You wonder, are there support issues from the distant past? They'd have to be distant past. And then he has his wife that had his wife of, as we said, 40 years. So people wondered, how will his estate be distributed, and even what precisely does his estate consist of? So I was curious too. And then when I first started preparing for this show, once we decided we were going to do this a couple weeks ago, I looked online to try to go to the courthouse and see what we could find out. So Cordell & Cordell has an office in Houston, so we used what resources we could to find out what was the state of the probate. Whenever you have a will when you die, somebody has to file it with the probate division in the county in which you lived, you resided, or in which you were to be found when you died. A couple of options, but either would have been in the state of Texas. Matter of fact, both would have been the same county, which is the county in which Houston, Texas is in. So we looked originally and found nothing filed. There was nothing having been filed. Now, this would have been going on 2 months from the date of death, going on 3 months. Yeah, from the date of death. So we thought that was a little odd. You can take as much as a year to file a will, so it's not entirely unusual, particularly when maybe there's nothing pressing that needs to be done, where you have a surviving spouse. Often you have assets that can be accessed by that spouse when you die because her name or his name will be on the assets. But if you don't have a spouse, when somebody dies, certainly $300 million or let's just say much less, but they have stuff. So third parties, and think about it, even if you have a bunch of kids, how do they get to it? How do they have the rights to do anything? Because all the titles normally resist. The way we hold titles in the Western world is in our names individually, sometimes an LLC, sometimes other corporate form. But the bottom line is, in order for a stranger, and I use that word technically, even a son in legal terms is a stranger in the sense that just by virtue of being your child, they don't get your Social Security information. They don't have access to your health care. They don't have access to your life and your property, thankfully, many would say. So how is it that person functions? And the answer is, well, you have somebody who runs to the courthouse, so to speak, and they get something filed and they get authority to be able to act on behalf of the estate to marshal assets, it's called, to prepare an inventory of assets, to get this stuff as soon as you can in front of a judge and get a gavel going down saying, yes, there was a will, and yes, we see we've concluded the will's valid, and yes, the assets will be distributed per these terms, and the estate's closed. After, I'm obviously grossly simplifying, and that has to be an opportunity for creditors to get paid. So in this case, though, we had a surviving spouse. So often, she may be able to continue functioning without any sense of urgency in order to get this changed over. Mm-hmm. So that's what we suspected. I think that is the case. What we found out, coincidentally, I had one of our attorneys to look again at this. I want to say last night. Maybe it was yesterday afternoon. And then we found out that just filed yesterday. Just yesterday.
What a coincidence.
Yeah, hot off the press here. We don't try to be news here as much as being helpful information, but in this case, it's news that this was just filed without fanfare. This isn't going to grab attention in the press because whenever you file something with the probate court, there's no need for there to be notification, although there will be soon. But we don't have to get into that. That's when you file notices to the public to come forward, and usually this will appear in a legal periodical of some sort, so the average person doesn't read it, but lawyers do, and banks and corporations that where they have an interest when somebody dies, and say they have their lenders, or maybe they have mortgages on assets, whatever it may be. So in this case, other than that, there's not going to be the interest here, but what we found out from just what was filed, the order that was issued yesterday was filed the day before, but we found, and this is Harris County, Texas, which is where Houston is, the proof of death and other facts. This was filed by the lawyer of the law firm that prepared the will, and this will was prepared in 2008. So Matthew Ballman is his name. He's with a respected firm in Houston. And it states George Foreman died March 21st, 25, Houston in Harris County, age 76. And that state that he prepared a will that was filed with this document in 2008. And this document is asking the court to acknowledge this will. And it's asking the court to appoint somebody with what's called letters testamentary. What this means is that whenever you come forward, in this case, the wife, Mary Joan Martelli, and she has this attorney who's filing on her behalf, but she's asking that the court acknowledge this will, that the court appoint her according to the terms of that will as the administrator or executive of the estate, giving her these what's called letters testamentary, which means that she has the power and the authority to go out and to do the things that I just mentioned a moment ago, where you file a document, a will with the probate court, and then the person who's appointed personal representative in some states, in other states they're called executors, and in Texas apparently they're called executors. And this person is appointed to be the arms and legs of the court that goes out, does the inventory, meaning marshals, gains control of the assets that are out there, assures that they're not being depleted or depreciated in some way. So their job in marshaling assets is to know where they are, to know they're protected, and to know that they can be safe until ultimately distributed by the court. So that role is important. And in addition to marshaling, you also prepare an inventory of all these assets, because the court, remember, only knows what somebody brings the court, and the arms and legs by which that information is acquired and these things are done is through this person who's appointed. Often in the will, they're asked, but the judge will ultimately approve that, and generally does. So the will, we know, had named her to be the executor, and then there were several alternatives, one which included a couple of the kids as an alternative if she had passed away or something. So now she, beginning yesterday when this order was issued, she can now, and which will be done through her attorney, will go out and prepare this inventory of assets. Will give creditors the opportunity to come forward. So there'll be ads that appear in this legal periodical I mentioned. That can be any number of periodicals in Houston that would meet that definition. And it states that he died, and if you have a claim, gets the estate to come forward and present it. So she will, through her attorney, will go out and prepare these things and let creditors come forward if they want. And then either the estate will acknowledge the validity of these creditors and these debts and pay them, or they won't, in which case they'll challenge them. And then that's when you have battles in probate court. The other opportunity, though, is for people who would be the heirs if the will were not valid. They have to be notified. So if under the intestacy laws in the state of Texas, like any other state, they have laws that say, well, if there is no will, these are the people that get it. Well, those people get to be notified if there's been a will filed after a death. And why? Because what if the will were invalid and the person who brought in the will were the named beneficiary, the only beneficiary, and the rest of the family member wouldn't know because they wouldn't get notified because the will's accepted. Why would they be notified when the will says everything goes to this person? So what among the people that are notified are creditors, known creditors, this publication, and then finally people who would be candidates if the will were held invalid. And it's true in most states. I assume that all that's true in Texas. It appears to be from the documents that I have in front of me. So I did have copies of these sent to me, and there's not a lot of detail here, at the risk of disappointing you some, but I will say that this is a case where we had somebody who, as early as 2008, prepares this will, which was not substantially changed since that time, though there's been only one death of one of the beneficiaries, which was the daughter we mentioned in 2019. But other than that, no one else has died, and there's not been a remarriage or a divorce or those things that will affect wills. So this will has not been amended since that date. And it appears that what they've done, when you look at, let me go over here to a copy of the will, which is filed with the court. What they've done is created what's called a pour-over will. We've talked about it some on this show, and it's a very common device where you have what's essentially a revocable will, and you put some of your assets you have a revocable trust. You put some of your assets in that trust while you're alive. Ideally, you put all of them. Theoretically, there are some reasons you don't do that for some. So you just change the title on it and put the name of your revocable trust, and you don't lose control of the assets, or it doesn't have any of those consequences. That's what's typically done. However, another thing that's often done, and in this case, I think it probably will include quite a few assets, is that there will be assets that are not named other than their titles, which will be the name of George individually, or maybe George and partners, in some cases, and a spouse, depending on whether survivorship rights, et cetera. Won't get into that. So it's not uncommon to create the machinery of having a revocable trust in existence, but then creating a will that you really know is going to capture a lot of those assets when they die, and then the will simply has one instruction. And that instruction is in the last section of the will, kind of the bottom of a drain, in which you can say, well, this can go here and this can go there. Specific bequests you often make in your will. I want my son to have my shotgun collection, whatever it might be. And then when you say, oh, and everything else, that's called the residue provision, residuary clause. And in this case, the residuary clause is clear. Jumping down here, it's clear that the estate goes to the George and Mary Foreman Living Trust. So that's a revocable trust created by George and Mary Foreman while they were alive. They probably have some assets in it already, but they kind of figured, look, if they're like most people, they didn't put a lot of assets in there already. And it means that those assets are going to go through the estate. And that's not something that we recommend to clients, quite frankly, but it's commonly done. So in an indirect way, this puts everything in the trust with the same set of detailed rules. So what's a little dissatisfying to us is that we would like to know what the specific distribution was. And whenever you do it this way, one of the advantages is that all you say in the will, like I mentioned those specific bequests further up, well, there are none of those. And it simply has a residuary clause. So you go all the way down to the final section of the will in which it says residue or residuary, and then it says anything that I've not previously assigned in this document, which there was nothing assigned previously in the document, will go to my trust. So it takes this pile of stuff, whatever was in the names of him in some form, partner, singularly, however it might have been, his interest will be taken directly from the probate estate and ordered to be given. The beneficiary ends up being the trust. So it goes to the trust, but it doesn't end there because the trust is where the action is about all that it tells about who gets what. So, all those things that I would like to know, and presumably you're watching this show, you would like to know, are going to be in that trust.
The private stuff.
Yeah, meaning, how much do the kids get? I'd be very surprised if you said everything to my wife and thinking that when she dies, it'll end up with the kids because they're not all her kids.
Yeah.
That would be unusual. So I'm betting that there's a pretty detailed set of provisions in that trust.
Yeah, with that many kids.
With that many kids. And I would be shocked if he didn't provide for each of those kids in some way, knowing the way he lived his life with them, particularly his later life with them. So I wish that this were more helpful to us. But remember, one of the reasons we tell clients you want a trust, a revocable trust or an irrevocable, but irrevocable we don't talk a lot about because that's generally people who are thinking more about tax issues or asset protection. But if you're just thinking about a will where you can assure that your plans, however complicated they are, can be carried out in privacy and can be in place for a long time. You create the trust, it can carry on for decades. And often you want to do that for kids. I argue you would do that for every child, incidentally, not just kids you think have bad judgment or special needs. I would argue all kids benefit from that. But anyway,
well, even grandkids in some of those situations.
Probably, yeah, and there are probably provisions relating to that, which may have some tax consequences. So that's the way this was done. So what's interesting, though, is that because I'm willing to bet there are assets that were not in that trust, that means that they're going to be publicly disclosed. Now, remember this inventory I told you to mention, that I mentioned to you a while ago, where whoever's the executor goes to the court and says, appoint me as the executor so that I can give me letters testamentary to give me the authority to go out and find out this stuff. That only applies to things that were in his name that would go in the trust, that would go in the estate. So remember, anything that's in the trust that they transferred already, that doesn't get in here. So here, it'll make more sense to you if I put it to you this way. So if when they created this trust, they put everything into it, if that was what they had done, put everything into the trust out of his name, which is possible, and we have some clients who do it. It's a little more trouble because some things you don't want to do, but you could. You could put your house, you could put your cars, you can do all sorts of things. And you can also have provisions by which you can have things automatically go into a trust at your death. Survivorship clauses relating to insurance or transfers on death that happen automatically. Those don't go through probate. Those go directly to the beneficiary. And so there are a number of devices by which you can have things either already in the trust or they go into the trust immediately when you die because of some special rule. If you did that, there would literally be nothing in your estate. So if they did that, then what Mary would come in with is a blank sheet of paper in terms of the inventory, and there's still the issue of are there any creditors that need to be paid? And then that's a question of what they're going to be paid with because there's nothing in the estate. Remember, it's the estate that's at issue, and only things that are in the deceased's name go into the estate. If the person had nothing in their name because they create a trust, like a family trust, a living trust, and they put the assets in it, then when they pass away, there's nothing to go into the estate. So it is possible. It's what we're going to find here.
So does that mean the creditors if you owed any money and you had already rolled all that over, that they're just SOL?
That's a complicated question. I'm going to dodge it. And the reason is that there is, under the Uniform Trust Code and the Uniform Probate Code, there are provisions by which sometimes the court can reach something that was transferred to a trust if it was done, if the person still had complete control of the asset when they died, even though it was in the trust. So in other words, if it was an irrevocable trust, the answer would be, if it's done correctly, then it's immune. It can't be touched. But a revocable trust, under some conditions, and I'll just leave it at that, under some conditions, the court can take from that if there's nothing in the probate estate. But even in those conditions, whatever's in the probate estate has to be exhausted first. So this is an important rule. So most people don't have nothing in their estate. I mean, they have some things go in their estate, as I mentioned. So the most common remedy in most states is only after that has been exhausted. So in other words, if you had some things go in there like a piece of real estate, and that was enough to cover all those claims, then nothing could be reached in the trust because it has to exhaust that first. So it's helpful in terms of asset protection in that way too. Not as helpful as an irrevocable, but an irrevocable is a little more of a headache, and it has wonderful points. I personally have one, and a number of people I know have one, and some of our clients, but by far the vast majority of our clients do revocable trusts. And in this case, this is what was done here. And I'm betting, though, that there are some assets that were not there. We'll know what those are. Those will be filed publicly. So we'll see it. We'll see what those are. And if you're that curious, that will be available in the time period that she has to provide this. And this residuary provision names only the trust. So, which, again, is what we would expect. I just want to be sure. Furnishes the following information to the court for probate of the written will of George E. Foreman and for issuance of letters testamentary to applicant. So the court, the application was made on the 16th, and on the 17th, we have the order from the court granting the letters and appointing as executor Mary Foreman. The will, of course, there's nothing in here additional that I would point to that would be of interest. Of course, in a will you have to describe, who are the children, and so you want to make sure that the person preparing the will acknowledges or knows of the people that would be the natural benefactors in their life. Not that they will be in the will, but they have to be disclosed, that you acknowledge that as part of competency to prepare a will. Appoint my wife to be independent executor of the will. It's interesting. The alternative to her would have been George the Fourth. He's probably a good business guy.
Oh, yeah. That'd have been Big Wheel.
Oh, it would
right?
have, no, jointly. So is that Big Wheel, George?
Yeah, let's see. Yeah, the fourth is Big Wheel.
Yeah, so
the movie producer.
There you go. And Leola Foreman. So they would have jointly served as executors.
And that's a comedian. Do you want the comedian in charge of your stuff?
Well,
Kidding.
It can change an otherwise sober situation, and definitely attending the wedding or the funeral. So there's nothing else most of this is all standard, the rest of it here in the will. There is multiple pages, just so you know. It's like 15 pages. And then you have the execution, signature, witnesses. So the lawyer, reputable lawyer, knew what he was doing. One thing I will say, though, while this appears to be a perfectly okay plan, and I'm sure that this is something that George gave a lot of thought about. He didn't need to change it. Still, they would have been hit with a substantial amount of taxes at death. Now, in this case, you should know the advantage of having a surviving spouse is that you have kind of an unlimited marital deduction, it's called. So you can actually postpone paying taxes, even if you had $1 billion. You can postpone paying taxes until the death of the latter. So in this case, it could be pushed off, and depending on what the exemptions are at that time, it could mean that there's not a lot of taxes that will be owed by the beneficiaries thereafter. But whenever you create the sort of trust that I described, it's a see-through trust for purposes of the IRS. The IRS doesn't regard irrevocable trust as being something that will affect your tax liability. You had control of those assets when you died because, remember, it was revocable. So he had control of those assets when he died. So it didn't affect, it wasn't a device that was intended to save taxes. And I think maybe the thinking was, we're not going to worry about that here. We don't want to create an irrevocable trust. Apparently they decided, unless it exists and we don't know about it and there are assets in it. That could be true. We don't even know about it. But assuming that that's not the case, and it's believable that it's not, because it is a little bit of trouble, as I mentioned to you. So he may have said, I don't want to fool with it. His wife may have said, Mary may have said, I don't want to fool with it. So they never created an irrevocable trust that would have reduced permanently their taxes. So in this case, I think they were thinking, look, George, after his death, Mary won't have to deal with losing a substantial part of the marital estate in taxes. But when that time comes, yes, the kids will. Now remember, the way federal estate taxes work, unlike the taxes related to, say, the estate. The states sometimes have what's called gift taxes, where a gift or inheritance taxes. That means the person paying the taxes is the recipient, and the recipient of an inheritance tax is going to be the person who got the asset. So that means each of the, say, 12 kids each got something. So depending on whether that exceeded the floor or the exclusion that would exist for that state, then it means that they're paying those taxes individually. Not true the way federal estate taxes work. Federal gift and estate taxes work to where it's the person who died or who's giving, they owe the taxes. The person receiving doesn't owe anything. Now, that's of little consolation to the person receiving it because, if it's a $300 million estate and there are $100 million in taxes, obviously it's going to affect how much is available to be distributed. So in this case, it's true that we can be pretty confident that that if it's $300 million, if that turns out to be the number, and we may never know. Again, we'll know what comes through here, but we won't know what was already in the trust. But if that were the number, it means that Mary will live without any diminution of that due to estate taxes. But when she dies, there'll be a big chunk unless we raise the exemption much higher. The exemption now that Trump's proposing is $15 million per person, which would be $30 million for a couple. So, but when she dies, it'll be $15 million if that legislation goes through. That's in the current budget plan that hasn't yet been passed. That's been proposed by the House or the Senate. I don't know which version it is. So, but think about what's left to be taxed. I mean, if it continues to be just the same number, $300 million, which presumably it would be at least that. It's hard. I mean, she's going to get enough income from the $300 million where she shouldn't have to buy it into principal. So, I mean, at 40% rates, remember, these rates on estate and gift taxes go up like this very sharply. So by the time you get to like $15,000, you're at 40%. So that is a huge amount to pay in taxes if you didn't have to. Yeah. Now, those of us who think, well, I think I would be okay with what's left from after taking 40% from $300 million. But why would you let that happen if you didn't have to? Mm. And so hopefully there will be some estate planning that will be done to avoid that later on. George, kind of my walking away impression is he made a lot of good decisions in his life. He did. He made a lot of good decisions in his life, and I think that he's a role model in many ways.
He left behind quite a legacy, I think.
Yeah. And I think that I'm confident he has taken care of his family in his estate planning. So I hope you enjoyed this discussion. This has been another episode of Life's Third Act. Till next time, take care.
And like us, follow us.
Yes. Remember to like and subscribe.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.